Today is 196th Friday group meeting. The topic is India's new data privacy laws and cyber security. The speaker is our beloved Dr. Vidyottma Jha, one of our prominent Friday group member. A lot of details we got. I request Nilesh Pavani will say a few words about her. Nilesh, can you take initiative, please, sir?
Thank you, Sheshu sir. We welcome you, ma'am. I'm reading out some parts of her CV which are very relevant and topical for the kind of presentation she's going to give. Ma'am she has done her BA from Patna University in 2003, her MA in Political Science from University of Bihar 2005. She did her law LLB from Campus Law Center 2009. Joined the profession in 2009 and has done her PG diploma from the Indian Law Institute and subsequently obtained her PhD in International Relations from Patna University. Ma'am has been a very sought after speaker. She has spoken at various law colleges, events, seminars, webinars, conferences. I mean, the list can go on, and I'll be eating up your time if I go on mentioning them. Apart from that, she is also a very avid writer. She has published she has contributed a number of chapters in many books on subjects like youth technology, media, which is pertinent to the topic that she's going to address us on. She's contributed a chapter on neuro jurisprudence in criminal judgment, which is again forward looking and forward thinking jurisprudence which will come around. And she has authored a book on international relations titled Recent Trends in India and EU Relationship, published by the Lambert Academic Publishing. So we welcome you, ma'am, and we are eagerly awaiting to hear you on this subject. Thank you.
Thank you, Nilesh. Thank you, sir. We already circulated her CV in our Friday group. You can adjust yourself. It has to be on.
Hello everyone, and I'm really very grateful to Sheshu sir for giving me this opportunity and having me here. And the topic is very current, very relevant, and the act itself came in August 2023. So I think it will evolve with time. There's a lot to be done in the act. There are much lacuna. But still the act is actually required in our country. It is that data protection law was much needed despite the Information Technology Act being in place, because it will establish guardrails for how organizations should handle personal data and offer citizens control over the personal data that are being gathered from them and how that is being used. So what is data protection? First of all, data protection is the consumer's right to privacy. The right to privacy that actually is enshrined in our constitution. The international regional laws, conventions are there, and our constitution is very vocal about it. Just we have to understand it, and it was actually very much in the constitution, but we got to know about this later in 2017 when it was very emphatically discussed and given place in the judgment case Puttaswamy versus Union of India. So but data protection is something wherein the law is designed to protect us. The informational privacy is given much place, and it is actually dealt with that wherever the original laws and conventions apply, or the Constitution of India applies with respect to our personal information, the abuse could be protected, because there are data that are being collected from us, processed and stored in automated form, and later there are institutions, the companies or some organizations, they collect the data from us, they use it, keep it, mine it, whatever they want to do, and we don't know about anything that is going on. So we need those laws or those protective measures to protect ourselves, protect the abuses that could be done with our data, and we might get to know, but until then it might have caused much loss to us. So data protection, what is the need for data protection in India? Actually, India has become a big IT hub, and so the need emerged with the India's growing outsourcing and the way we are actually using internet these days. So the need actually emerged and evolved with time. Earlier, India was not into this zone itself. Now the things are becoming very much updated, and the need emerged with that. So even in countries like USA, recently there was an incident that America actually alleged China of hacking the details from the high security zone of Pentagon. So let's think about India, how India is going through the crisis. Like a few years back, somewhere around 2 years back, we heard about our data, like especially the Ministry of Defense, the data was actually compromised, and some links were directed towards the porn sites. Then the PMO's cyber security was also compromised, and for months it was compromised, and we don't know what important data have been actually stolen. So the consequences may come later sometime, but this actually raises, this is alarming, and it raises concern over our things that what is actually going on. So Information Technology Act, despite being a very effective act, it could not actually give us that kind of support that we needed with respect to our data, and so it was actually amended also in 2008, and these two sections, section 43A and 72A, were added. But still it was grossly insufficient to cater to the need of the consumers and the data principles, with popularly known as consumers. So it was much sought after act, and so when the Puttaswamy judgment came in 2017, it actually showed the way, though it did not lay down the contours of the method or the specific mechanism how the right to privacy has to be protected, how the data has to be protected, but it laid down certain path that it needs to be addressed, and it is important. It is important to protect our data, and informational privacy is a fundamental right of the citizens of India, and so there should be a certain kind of measure, act or procedure which actually caters to the needs of the individuals. So in 2019, the government of India came up with the Data Protection Bill. But actually it took long time. Actually it came in 2018 first of all, and Ministry of Electronics and Information Technology had set up a committee under the chairmanship of B.N. Sri Krishna, and then that committee actually studied the things, and they came up with certain regulations that were actually popular and that were actually required at that point of time. But when it came to the public consultation, it did not find ground, and the government of India withdrew that, and again came up with another fresh fresh set of laws and everything, and the bill was called the Data Protection Bill 2019, and the report came in 2021. And for public consultation it was given in the public zone, and then again the government of India actually worked on it, and then came with the Data Protection Act 2023. So it took 4 or 5 deliberations to come to the final act, and then this act actually came into the picture, and now it has certain, it is based on the basic 2019 bill. So it is actually the first cross-sectoral act wherein it talks about the data being transferred to some location, or what are the applicability of this data and everything. So but there is no date given as yet for the effective implementation of the act. So they have just said that they will take probably 10 months to implement the act, and it may come up in parts as other legislations have come. And it does not provide, the act may come in stages, it does not provide any grace period for the compliance. The applicability, the government announced that the act will be personal data is maintained in digital form and applies to the processing of personal data outside India. Only if such process is in connection, but it actually cares to see that the data has to, data principle, the consumer can only avail those data from the foreign land if the services are available within the territory of India. Nobody can access to those data which is actually in the foreign land, because it is they think that this is for safety, but I think this is counterproductive, which I will come to later. Then there are certain grounds for collection and processing of data. The first and foremost and the primary ground, the legal ground, is the consent. Consent is the most important ground for processing personal data and legitimate uses. The consent means the consent should be unconditional, consent should be unambiguous, and there should be some affirmative action that shows that consent is being given. For that consent, the consent manager is also allowed. Somebody if wants to have a consent manager, they can have consent manager to manage their consent. But the collection of data could actually be done without consent when it comes to legitimate uses. Legitimate uses would include the when the data is used for the upon the order of the courts, or there is some emergency, medical emergency or epidemic or any kind of state emergency. So data can be used without asking for the permission of the data principals. The data fiduciary can use it. So otherwise also to protect the employer, to check on the employer and employee relationship wherever it is required. Then there is, if somebody is voluntarily giving their data to somebody, like if we are going to a pharmacy and we are giving our data voluntarily, we can, that data is voluntarily given. So nobody can question that. So there are some legitimate uses of data which cannot be restricted. Then there is a notice period for a data fiduciary. Data fiduciary would include all the companies, institutions, institutional arrangements, even the government, whosoever is asking for the personal data to be processed for the purpose of processing. So data principals must also be informed over their right to withdraw consent, and what are the grievances, what grievance redressal they could get from the data fiduciary. So a notice must be accessible to them in English and in 22 languages specified in the 8th schedule of the Constitution. Then our law is also taking care of our children. The applicability with respect to children is, the law says that anybody who is below the age of 18 will be considered in this category, and verifiable parental consent is required for collection of children's personal data. Other than that, there should not be any target advertising to influence the kids to take care of their well-being, so that children are not influenced by wrong data fiduciary. But there are certain exemptions that our government has, and they can restrict or allow somebody to take the information in this respect also. Then there are the rights and duties of data principals. Data principals are consumers, so they ought to have some rights while giving away their information or the data that we are talking of, the protection of that data. So that Act grants several rights to data principals, including right to know that personal data is processed, right to data deletion, correction of the data, updation of the data, and updation of the inaccurate data. So data, it also imposes on data principals a certain kind of duty, like they should not provide false information and not to lodge frivolous false grievances against data fiduciaries. Then there is integrity, deletion and protection of personal data. The data fiduciaries have to ensure the completeness, accuracy and consistency of personal data, because the decision that is about to be taken with respect to the data principal might get affected. Also, where data is disclosed in another data fiduciary, that might impact the data principles information, or the kind of business is going to be done. Also, the data fiduciary must delete personal data when the specified purpose for which it has been taken is served, and if at all it is kept or retained, is required to comply with the applicable law. So data fiduciaries must also use reasonable security measures to prevent personal data breaches. Personal data breach would implies that an unauthorized processing or accidental disclosure, alteration, use, destruction of personal data, the confidentiality, integrity, or availability of data. So in the event of personal data breach, the data fiduciary must inform both the Data Protection Board of India and data principals in a manner prescribed by the government. So the personal data breach has been taken care of, and there is also significant data fiduciary. The Act retains the principle of data fiduciary, but there is a criteria set forth by the government. For determining the significant data fiduciary, the government will consider factors such as volume of data being processed or data fiduciary by the data fiduciary, and potential risk to the rights of the data principals. The potential risk could be sovereignty and integrity of India, damage to the electoral democracy, security of the state, etc. So significant data fiduciary must appoint a data protection officer and an independent data auditor. This is for the purpose that data protection officer has to take care of and also the grievance officer. All these officers are to take care of the complaints of the data principals, and data auditor is to audit that the act is being complied with. And then there are data processors. The Act requires data fiduciaries to execute a data processing agreement with its data processors. The data fiduciaries are responsible for their data processors' compliance with the Act. Then data localization and data transfers. The Act empowers the government to create a negative list of those countries to whom personal data cannot be transferred. So other means of transferring personal data to blacklisted countries, such as standard contractual clauses, explicit consent, or intergroup transfers, are not covered by the Act. So there is a lacuna, but there only I meant that it is counterproductive. There are government exemptions also. The Act grants the power to the government to exempt itself and its agencies from most requirements of the Act on certain grounds, such as sovereignty and integrity of India and the security of state. But these grounds are broad, and proportionality and reasonableness are not required. Here the judiciary may intervene because the jurisprudence has already developed in this regard. Then there are other exemptions with respect to the data fiduciaries, and such as startups, and they have right to access, notice requirement, data retention limitations, etc. Then there is content blocking. The Act grants the government the power to block their contents for the public access to any information processed within India that is deemed to be in the interest of the general public. So upon receiving the reference from DPBI or the Data Processing Board of India, any institution can be asked to block their contents by the government for the public access. The Act also provides for the penalties for specific acts, especially if it is for the purpose of compliance, or the compliance with respect to safeguarding the security measures, and it might go up to 2.5 billion, approximately 30 million US dollars. So the Act does not contain a provision for awarding compensation to affected data subjects. So, if we critically analyze the Act, for the purpose of applicability, it is a very good Act, because most of the businesses will store some personal data, especially payment information in digital mode, and so almost all industry will be covered by the Act. So few obligations and the GDPR and similar laws is a positive factor for businesses subject to the law. But as far as notice is concerned, the requirement to make the notice accessible in English and in 22 other languages is a onerous task, and since most of the legal documents and services related to it are exclusively in English, it is a problem. So legitimate interest, act in India is actually making the legitimate interests or the legitimate uses little narrower compared to the European Union's GDPR, because the European Union's GDPR is a wide law, and it has many complications if we apply such laws in India, like especially if we go to the Sri Krishna Committee's report, and why it was not actually implemented. The thing is that it actually laid down certain regulatory measures, supervisory actions, which could not be applied to the Indian system, and if at all it was applied, it would have been over-regulated or under-regulated, and due to lack of experience, and the first time such kind of law was coming in India, it could not be implemented. So it took longer time than it would have taken. So 4-5 deliberations were actually held because of that only. Then consent. Whether India will require consent according to GDPR standards, because consent is a wide thing, because consent is for specific actions. Consent is should be unambiguous. Consent it should be clear, affirmative action, and much more. So here the GDPR is actually mashed, and there is a question that India is asking too much with respect to the consent. Also, the addition of the word unconditional for the collection of personal data raises the bar. It is a potentially higher standard of obtaining consent rather than the GDPR. The voluntary provision for personal data, it is actually poorly drafted, and a lot of things are not contained in the draft itself. Like a specified purpose means the personal data is given sometimes automatically when the transaction occurs, and there is no notice of the specified purpose given to the data principal. And it would have actually referred to the specific act of the data principal where he voluntarily gives his information. There are certain acts wherein the data itself goes due to the automated and the computerized systems. Everything goes from one place to another, so it is not clearly given that, and the text of the act actually lacks that. Then there is purpose limitation. It is also not well defined. The act does not require that the stated purpose of processing be legitimate. The act provisions that exempt the government from certain aspects of applicability directly or indirectly, wherein the judiciary actually intervenes, is not clearly given. It only states in some respects, directly or indirectly, the government can exempt itself. So it is actually going by the space that the judiciary can actually catch from there. Then there is foreign personal data. The Act largely does not apply to foreign data processed in India. I earlier mentioned about that it is only talking about data that is being transferred domestically. It's and if at all there is some data principal receiving the service from abroad, it should be within the territory of India. So it is limiting the zone of the data being transferred from one place to another place, and this is how it is counterproductive, and also the legislation fails here in its adequacy, and it will also not actually match up to the ruling of the European Union guidelines. So and also that what is the point in having such vast act and everything when you cannot match up to the international level? Then because Indian laws do not fully comply with SCREMS 2. SCREMS 2 is the European Union's judgment which recently came. It came in 2020, and it was actually fully applicable by 2021 June or July. So it actually invalidated the European Union and US organizations mechanisms of safe and safe flowing of data from US to European Union. Also, it actually spoke about the data being handled from other sources, from the third from this two organizations to third destination. It spoke about checking on the destination, and also the every data case on case by case basis. It actually other countries also started thinking that where their data is going, is that actually being managed properly. So it SCREMS 2 guidelines are also not fully complied with. Then a data breach notification. The requirement of the requirement to notify the data breach to the data principles by the organizations in India is very narrow, and the time limit is almost 6 hours. Within 6 hours everything has to be done, and which is actually stricter than GDPR of and European Union's guidelines. Also, there is a lack of power given to data processors. Also, the DPBI, there is lack of power. They are not given power. The government actually keeps those powers to itself, wherein the DPBI should have been given more power, because they are the nimble organization, tech savvy. They can actually discuss with the stock holders. Also, they can give recommendation papers, and actually the data protection law is an evolving law, so there will be lot of changes that has to be taken care of. So DPBI needs to be given more power, but the government itself is keeping all the powers. Then the privacy right that Information Technology Act actually spoke about, where the senior officer has to see that information that is to be given to the person who is asking for it outweighs the laws or not. And this time, if there was some scope, the information was being given to the people who are asking for information. And now the new law says that the personal information cannot be disclosed as a part of the right to information request. So there is a big change. And then at the end, I would like to say that Data Protection Act is a culmination of more than 5 years debate and deliberation. It marks the start of the statutory personal data protection regulation and the regulatory developments and institutional arrangements that take shape over the next few years. That will decide what the personal data privacy is and how far it is protected, how far government has gone with the idea that it has put forth. Also, it is good for the business houses, because it is not that costly, and the law itself is pragmatic. A significant degree of discretionary power on substantive issues is vested with the central government, and it is up to the government that how much it is committed to protecting the privacy of the stakeholders, the data principals and the data fiduciaries as well. Thank you so much.
Yeah, thank you. Thank you, Vidyottma. You made a lot of hard work, a lot of information you were given, even though it's a new act. Napinaji, have another 10 minutes. You can put some light. We are all enlightened. A lot of gathering is here. One of the experts. So that you take. No, please sit. She will carry that. I request Napinaji, one of the prominent and cyber experts. So put some light on this. Even though I know I have valuable time, you are short.
My apologies that I do not want to intrude on today's session. Thank you for a very comprehensive presentation, ma'am. I would actually rather address a couple of questions if any of you all have some. I have only 15 minutes now, my apologies on that. But if you have some questions, I'd rather address it. If you want me to just add to whatever has been presented, I'm happy to do that.
Add it.
So yes, so you have heard a little bit of the background to what you have as what is called as the Digital Personal Data Protection Act, or DPDP. Now, the reasons for the two qualifiers, the prefixes of digital and personal, is for the reason that if you must have heard of a lot of data breaches, which will be with respect to your name, your personal details, your credit card details, your debit card details, your health information, all of this is considered as personal data. Now, if you look at how your Google Maps works, it collects information of how many mobile phones are available in a particular area and then maps the possibility of heavier traffic based on that. Now, that collection of data does not specify whose mobile phone is in a particular location. It merely talks about X number of mobile phones in a particular location. Now that is called as anonymized data or non-personal data. Or I would put it slightly differently, that is non-personal data which could be anonymized data. And the difference is as follows. That data which you cannot relate to a specific person, which you cannot use to identify a particular person, is non-personal data. When you take personal data, for instance, if Google is actually receiving information about whose mobile, maybe even the number, or definitely your IMEI number or the mobile device number, and other details about you. So it has your name, your location, your number, etc. with it. But what it is using is something which is anonymized, which cannot be reversed, and where you cannot show it belong to NS Nappanai or XYZ, right? So that is called as non-personal data. And therefore, this Act specifically talks about it as Digital Personal Data Protection Act, because it only refers to how and in what manner your personal data should be dealt with. It does not go into the issues of how non-personal data should be dealt with or any other form of data. Now, what is the third category one could think of? All of us now understand the importance of confidentiality. So particularly, let's say if you're talking about intellectual property rights, you've heard of so many instances where intellectual property rights has been violated. You've heard of, and I think there was a session which Mr. Sheshagiri Garu had organized about employer-employee rights and employees violating contract covenants. So when that happens and certain data belonging to a company or to other persons, that is proprietary data or confidential data or intellectual property related data, that is also a data violation, that is also a data breach. But those are categorized as commercial data breaches. Again, that's not what is intended to be covered under the DPD. So you've already heard about GDPR in the passing. GDPR is the General Data Protection Regulation from the European Union. That is what we broadly consider the golden standard. So why is it considered the golden standard? So just a little bit beyond what you've heard about the background in terms of personal data protection laws. It actually started in 1995 with the European Union's first directive, where they set out how and in what manner your data should be protected. Our personal data may have been violated in many ways, including from your neighbor asking you where you came from. I saw you at this bus stop, what were you doing over there, etc. Right? And your grocer, the person you go to buy your provisions, the person you buy vegetables from, the person you may buy your clothes from knows about your taste, etc. There also, in a way, you could assume that data is anyway violated, so I should have been protected then. So why from 1995 and why the prefix digital? The difference is the quantum of data that can be collected about a person without that person volunteering it, and the mode and manner of analysis of that data, and how you can then be profiled and targeted. See, broadly, commercial establishments claim that they are targeting you for the sake of advertisement. But it could be for any reason, as you have now seen in terms of the use of artificial intelligence, big data analytics and quantum computing added together. You now know how even elections can be manipulated by identifying and learning about an individual's personal taste. For instance, one of the studies that came from Stanford used the data pertaining to the car that people were using. Another study goes by the area in which you live, because there is a lot of ghettoization in the manner in which people congregate and live together. So based on these kind of unrelated categories of data, they were able to predict the outcomes of elections. So this is how powerful personal data can be. In many other contexts, and we are now in the midst of 2 wars, right? Imagine the kind of power data can bring in, where you can actually identify a certain category of persons, where they live, and target them. So this is the power of data, and therefore when it became digital, when it reached the electronic medium, the necessity for a better protection of this data was necessitated and mandated. So European Union led the fray with its 95 directive, and then it replaced it with the General Data Protection Regulation or GDPR. And that came in May 2016 and became effective in 2018. Now the advantage that European Union therefore had was that it had an evolutionary process in implementing its data protection regulation. We have jumped in at a fag end, but where people would start in school and move to a PhD, we have moved directly to the PhD level and trying to go downwards. So we'll have to see how best we can deal with it. Now, if I were to speak specifically about the DPDP Act, as you know, Seshagiri sir just ambushed me in a way. So I will just inform you all in terms of whatever I can in about 5-7 minutes. Broadly, the construct in terms of understanding what personal data protection is about, why an individual needs it and why it should be extended, not because somebody else will violate it, but in spite of ourselves. Because you as lawyers, we are aware that the biggest enemy of privacy is surveillance. But I always say that the biggest enemy of privacy is convenience. Because for the sake of convenience, we will give up anything, right? Including our personal data. So, the law was meant to protect us in spite of ourselves, not just because of what somebody else would do. And I personally feel that unfortunately, despite the time that was taken in terms of formulating this law and multiple drafts that were shared, and more importantly, precedents that we had, and which is why I mentioned about the EU 95 directive and the GDPR, you also have data protection laws from multiple jurisdictions in the meantime, between 95 to 2018, or I should say 2023. So we had a lot of precedents to help us formulate our laws. Unfortunately, I feel that the basic construct in terms of what amounts to data protection and what should have been given has gone missing. I'll give a small example. The scope itself not only limits it to personal data, the distinction which I already drew, but also says that any data that you voluntarily give on, say, online platforms, and one of the examples or illustrations given under that is social media platforms, will not fall within the scope of this act. So then what relevance is a personal data protection law? To what extent does it really protect us? When we are talking about, you've heard ma'am on consent framework. So when the debates were going on with respect to the data protection enactment, the multiple options that were talked about was the consent framework and accountability framework. And what the accountability framework mandates is that irrespective of consent, you would still have to exercise certain restraints. And that is where beyond consent you had purpose limitation. You had the data principles being incorporated into law, which is of consent, purpose limitation, the law rules for how you will retain the data, to what extent will you use it, how will you store it, who can you share it with, who can you disseminate it to, and where can you transfer it to. So it cannot even be transferred to jurisdiction which does not have a law on par with Indian laws. Unfortunately, in this case, that's not such a big threshold to meet. That's directly drawn from GDPR. And one of the other things which I'd like to close out with, and I'd be happy to take a couple of questions before I leave. One of the reasons why the DPDP Act was mandated. So I just spoke about, and just to sum up, I talked about why it is necessary for the protection of each and every one of our individual data sets. It could be our just basic personal data. It could be what the current IT Act set out as sensitive personal data, or it could be what two of the drafts talked about as critical data, which was supposed to be of a higher threshold than even the sensitive personal data. So whichever aspect it may fall under, It is the law was meant to protect us in that aspect, but predominantly, and this is actually part of the GDPR also, therefore there is nothing wrong in terms of looking at the business aspect too. So the GDPR also says there are two reasons for the law. One is to protect personal data, but other is to enable businesses in terms of using that personal data. So here also under the Indian law, if you look at it, it talks about enabling businesses for the use of personal data, and that's why it is meant to also help particularly startups and MSMEs based in India to be able to grow. Otherwise, they will not be able to compete with the likes of big tech. So that was the other reason that was brought in. So whilst this is so, and more importantly, with the focus being encouraging India-based businesses to evolve, it necessitated that India would also have a robust data protection law, which will help us to meet the thresholds of other jurisdictions which have very robust data protection laws. Because if we don't meet it, their personal data, for instance, European Union territories, the citizens of each of the countries which form part of the European Union, the citizens' data cannot be transferred to India because till date we were under the category that we did not have a robust data protection law. So if this law was intended to enable such transfer, it fails that threshold. And that's called a list of approved nations, and the chances are we're not likely to be part of that. So as individuals, as lawyers, as practitioners, how is this law relevant for you? The first and foremost is from a very, very minimalist law which you had only under 43A of the IT Act and 72A of the IT Act, you now have a fully robust law. So to that extent, irrespective of the restriction that comes with the scope of the law being limited, you still have a better protection. Secondly, you have a notice framework, as ma'am had pointed out, which also talks about information to you about why data is being collected, to what extent will it be used, and when will it be deleted. So the deletion aspect again is something I wanted to focus on before I closed out, because unfortunately again there are a lot of loopholes in terms of distinguishing the deletion laws or provisions that apply to corporates as opposed to the government. And there the ambiguity is likely to substantially compromise our rights, and one is hoping, and I would say that it would be very premature for us to jump the gun and just trash the act. It's just a very basic act. It's already been clarified that they are following the principles and rules format. Meaning what they are doing is they have kept the law very minimal and they are hoping to build in all the guardrails under the rules. So we would have to wait for the rules to come out to really evaluate the strength or weakness of this act. But until such time, going by the provisions which you have something slightly better than what you already have. So to that extent, it's a better provision or a better move. But to what extent it is going to protect you? To what extent does it give you remedies? Because a lot of it is left to the authority to prosecute, left to the authority to decide in terms of violations and penalties, etc. Talking about penalties, this is a very unique law which also imposes penalties on the users. So it is again a very ambiguous provision which just says if any user provides data which is false knowingly or violates any law. So that's where the ambiguity comes. If you provide false data, if you're going to be penalized, that's fine. But violating any law, etc. is very open-ended, and there is a 10,000 rupee penalty on that. So that one was hoping would be relooked after the public consultations, but it remains as part of the law till date. So there is a lot that can be talked about even with respect to the draft as it is. But given the time constraint, I'll stop here just to say that something is better than nothing. But how far this something can help us more, we will have to wait and see after the rules are framed and after it is implemented. And thank you again, Seshagiri sir, for this opportunity to intervene.
Thank you, Napinaji. You are always nice. You are expert. One of the further enlightened and strengthen our Vidyottama's topics today. We are grateful to you. Even though we have taken last minute request, you are supposed to catch immediately flight. We are all please. Any questions, please immediately. 1 or 2 questions will take. You can remove that.
For question section, if everyone wants that, then I would like to put to the Honorable Ma'am one sort of the question. Kindly,
Yeah, let's carry.
Ma'am, whenever we are having the discussion, healthy discussion with regard to any of the act, otherwise any of the statutory provision of the law, we simply define the execution of the law, process of making the law, process of making the statutory provision. As far as the pragmatic application is concerned, we are not having the focus on that particular issues. I have got 1 and 2 cases of the cyber law, because the topic that has been given from the side of the Seshu sir, that the cyber crime also, cyber security also. I have got the cases. Cyber in the topic, that particular words was included. So that's why simply just I have got the pragmatic sort of the example and experiences. That's why I am putting, because both of them are having the too much expertise with regard to that. Personally, I feel it that if you file that the cyber crime to any of the PS, in the IT Act it has been mentioned that particular officer will refer to the relevant cyber cell. In the IT Act, you might have known with regard to that. But as far as the substantial result is concerned, we are not having. Are you?
Please, Vidyottama, please.
Suppose that any of the cyber crime has been committed, and anyone who is aggrieved is going to refer to any of the PS. In the IT Act, it has been mentioned that the particular PS will refer to the concerned cyber cell. But as far as implementation of that particular execution of the statutory provision, we have not been able to have substantial result. Yes, why?
Yeah, please. Please let her.
Substantial result.
Yes, substantial outcome with regard to having investigation, inquiry, conclusion of the trial. We are not having.
It is not effective, which
Yes.
is why the
One minute.
Data
Let her
Protection
give
Act,
answer.
has come up.
Yes.
It has, had it been very effective with respect to the things, or it has delineated the function that and all the data that is stored on the computer,
Yes.
the present act would not have been coming. It would have been enough for us. It is grossly insufficient. It is not providing the kind of
Do you
stuff.
agree with that? Insufficient law.
Yeah, I agree, because if it was not insufficient, why
But
would
in
Data
IT
Protection
Act, madam, it has been clearly mentioned, if the crime is reported, that the concerned PS will report to the concerned cyber cell. In the IT Act, it has been explicitly mentioned, but so far the result is 0.
that the application of law and the result is not our concern, right? The applicability.
Yeah, Sanjay, today's topic is India's new data privacy laws and cyber security.
So may I
Yeah,
quickly
please.
address
Please,
this?
yes.
May I just address it
Yes.
very briefly? Your question is primarily with respect to cyber crimes
Yes,
under the Information Technology
Yes.
Act, and whether there is effective enforcement or not.
yes,
Am I correct?
yes.
So I would slightly digress from what ma'am said, and to the extent that I would say each of us are responsible. So the first and foremost is one of the questions that you asked is, are the laws that are existing sufficient?
Yes.
So my answer to that would be, at no point of time will we feel that the laws are sufficient. There will always be this feeling that we need more laws. But before we start asking for more laws, we should evaluate how well existing laws are being implemented, and that brings us to the first part of your question. And on that, a very straight and emphatic answer would be no. It is not being implemented effectively.
Yes.
But what is the reason for that? The first and foremost, and this is just my opinion, it is not reality and it is not possibly a reflection of reality, but one could evaluate what are the other reasons for it also, right? The first and foremost, I believe, is there is a lot of ambiguity in terms of what are the cyber crimes under the Information Technology Act. Reason for that is when the IT Act was implemented in 2000, it was never meant to be a law which will combat cyber crimes. Please read the statement of objects and reasons of the original act. It was only meant to enable e-commerce. In 2008, the objects were also changed to include cybercrime as part of it. You had about 10 provisions under the chapter offences under the 2000 Act. Out of the 10 provisions, barely 3 provisions were substantive provisions. The rest were procedural. And out of the 3 provisions, you had such an ambiguous provision under section 66, which nobody could implement even if they understood it, or it was more abused than used. What did it say? If you want any person deletes, destroys or alters any data residing in a computer resource or causes it to be done or affects it injuriously or causes diminution of value is committing an offense. So how does somebody, a common man, Kartar Singh is what I'll take you to, right? How does a common man who is supposed to function within the parameters of law understand what is it that he is permitted to do and what is he not permitted to do, so that he can then remain within the parameters of law? So effectively, whatever Kartar Singh said was what was violated with this provision, which is that after somebody committed an act, police or court were evaluating whether someone did commit an offense or not and then implementing it.
Correct.
So now what happened after the 2008 amendments is 66 was, it is not deleted from the statute books. It was transposed into 43, and there is a strange addition which is a variation of section 65, which is about tampering of source codes. And what do? They make all the offences under 43, which are sub-clauses, an offence if committed dishonestly or fraudulently. And that is what you have as the new section 66.
Yes.
So effectively, all the cyber crimes you're familiar with, which is hacking, virus attacks, denial of service attacks, each of these, data theft most importantly, including what I talked about, commercial data theft, etc. Each of these are subclauses under 43. Each of these could have been made into separate sections with very explicit headings, and I put in a qualifier here that we are all aware of the fundamentals of law, that headings are irrelevant in terms of interpretation of the law, but they act as signposts.
So my question was vindicated, ma'am.
Absolutely, there is absolutely nothing wrong with your question, but to merely say it as if it is somebody else's fault or problem doesn't help us, because we are part of the system. Therefore, each one of us has to take responsibility. When somebody comes to you with a cyber crime, and this is what is my earnest request before I close and run away for the day, is one, when someone comes to you with a case, please advise them to take it further in terms of prosecuting the case. Take it to its finality. Let us have a robust jurisprudence evolving, because till date we don't have a robust jurisprudence in India. So unless all of this happens, and most importantly, enough instances of punishments, enough instances of rather convictions, I would say, are made public, are brought into public domain, public become aware of it. That is the real deterrence of law. And that is not happening till today. Today, what does a criminal online think? He thinks that he is invisible. He thinks he can get away with it, and we are allowing them to get away with it.
One sort of the new modus operandi has come out,
Yeah.
changing of the voice.
That is part of the AI
the police
deepfake.
is not in a position to detect the real voice. And this is the biggest sort of the challenge in the forthcoming days.
That is part of the AI deepfake, and that's why the government has also said that they are going to create more awareness about it to protect.
Yes.
So prevention, protection, and then prosecution. The 3 P's we all have to go by, right? So each one of us has to contribute to a better and more robust and safer online domain. And I call my non-profit Cyber Sati for this reason, because we are all friends. We're all cyber friends. So let's all become Cyber Satis who will fight against this kind of, criminal situation.
Thank you very much, Vidyottma. So nice of you. You have given your valuable time. Napina ji also. Thank you. Moreover, we are not here Home Ministry or anything to make a battle, just to help you to exchange our thoughts. That's it.
We are having